Well, the Justice Department Wednesday released details of its strategy to rein in social media and search engines that have been accused of censoring conservative, libertarian, anti-war, and anti-authoritarian voices. And we don't know how this battle is going to turn out, but one thing we do know, it raises a lot of very important questions about the United States Constitution, freedom of speech, and what we can tell our kids someday about living during this crazy period of American history. As Lauren Feiner and Yolan Mui report for CNBC, Attorney General Barr and the DOJ are planning a two-pronged approach, the main spear of which is a reimagining of the 1996 Communications Decency Act, Section 230, which offers internet hosts and websites immunity from defamation suits and from state indecency prosecution if those web players act as platforms or merely edit items in what's called good faith. Well, additionally, the DOJ appears to be prepping antitrust suits against Google and Facebook. Looking at the former, Feiner and Mui report, the proposed reforms are the latest action aiming to weaken legal protection established through Section 230 of the Communications Decency Act, a 1990s-era law. The statute protects online platforms such as Facebook, Twitter, and Google's YouTube from being held liable for content their users post on their sites, and also allows them to moderate content in good faith. The DOJ's proposed reforms, which would have to be passed by Congress to go into effect, would limit the broad protection Section 230 typically provides to the tech industry. And this notice that the DOJ is seeking changes to the statute itself comes as a surprise to some observers who read Donald Trump's May executive order asking the DOJ to act on big tech censorship and saw in it rumblings that he wanted the DOJ and Federal Communications Commission to simply reinterpret Section 230. In the executive order, Trump's lawyers argued that Section 230 says that sites and carriers can be protected from liability from defamation suits and against state statutes for so-called indecency if they remain platforms. But they're also recognizing that Section 230 allows the platforms to edit as long as they're acting as good Samaritans. To facilitate their argument, the Trump administration executive order noted this key provision of Section 230. Quote, in particular, subparagraph C2 expressly addresses protection from civil liability and specifies that an interactive computer service provider may not be made liable on account of its decision in good faith to restrict access to content that it considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. So obviously, Section 230 expressly allows the platform to decide what is objectionable. But Trump's team focused on the caveat that the platforms do so in good faith. And they implied that the feds and states can define what is objectionable or not objectionable and what is in good faith. The Trump administration position is that if a platform does remove or flag material its owners view as objectionable, as Section 230 allows, the feds not only can claim the power to override that and remove their liability immunity, the DOJ and FCC could legally punish them, and states could go after them as well, based on an actual Supreme Court ruling called Pruneyard Shopping Center v. Robbins that allows states to provide more protection of rights than the feds do. The implication being that state attorneys general can sue the Twitters and Facebooks of the world because they're infringing on free speech on their own private platforms. So the original argument from the Trump executive order was kind of questionable, and itself appeared to be made in less than good faith, relying as it did on a new interpretation of Section 230. But frustration remained over big tech double standards regarding speech and the treatment of individualist-minded users versus those who promote collectivism and seem to get promoted on Google, Twitter, and Facebook all the time. Well, with this new approach, Barr and the DOJ appear to be backing off the original executive order approach and moving towards asking for legislative changes. Going back to the article, platforms could lose immunity if they facilitate or solicit federal criminal activity, like trafficking illicit drugs. It would also create carve-outs for child exploitation, terrorism, and cyberstalking, holding tech companies accountable for taking action on such content. Well, but that leaves a big question unanswered, everybody. Is it actually appropriate to pass this kind of legislation? Well, according to the Constitution, the Congress can arrange the court system above the state courts and below the U.S. Supreme Court. So based on the so-called rule book, the politicians in D.C. have the power, as they call it, to allow or not allow defamation suits and breach of contract suits against the big tech firms, making it possible that conservatives who feel mistreated by such firms could actually sue. Likewise, an originalist view, which is actually the only appropriate view of the so-called rulebook of the Constitution, actually shows us that only Congress is prohibited from writing statutes that infringe on the freedom of speech. As much as many of us might not like the idea that any form of government might infringe on speech, the fact is that many states had speech and religious codes and state-sponsored religious schools in existence until the late 1800s. In fact, the state of Pennsylvania was, of course, established as a religious state and was well known for having state religious schools and local speech codes until the late 1800s as well. So the possibility that the feds would lift their hands off the states to allow their politicians to sue tech companies for speech violations or for what they call indecency, well, that actually does conform with the original meaning of the First Amendment. But there's a bit more to consider and carry away for future consideration, and yes, to tell our kids about when we discuss this crazy time. For example, the proposal also would make clear that Section 230 protections cannot be used to dispute antitrust claims, a significant statement as the Justice Department is reportedly preparing an antitrust suit against Google for as soon as this summer. Facebook has also disclosed an antitrust investigation by the Federal Trade Commission. And that there, as much as some folks who are angry with big tech might applaud, is a pretty big no-no. Simply put, there's absolutely zero constitutional provision for antitrust laws. The 1890 Sherman Antitrust Act and its progeny are wildly unconstitutional and predicated on an open-ended, inappropriate interpretation of the Interstate Commerce Clause of the Constitution, which is found in Article 1, Section 8. And it merely states that Congress has the power, quote, to regulate trade between the states, end quote, with a capital S. It was, as James Madison warned people after taking notes at the Constitutional Convention, designed to act as a remedial measure to allow Congress to resolve trade disputes between the states themselves. It was not designed to give the feds omnipotent control over anything crossing over state borders. As Madison said, and this is quoted on page 408 of Makers and Takers, a great book by Edmund Kontosky. Mr. Kontosky, if you're watching out there, hats off to you. I loved your book. The clause was not written, quote, to be used for positive purposes, but as a negative and preventative provision against injustice among the states themselves. In other words, the United States was supposed to be a free trade zone, and the clause was in no way written to allow for antitrust at all. So the feds might take such action, but it's important to remember that the founders originally designed a different system, even as one sees how easy it is to be tempted to skirt their original intent. Well, the debate over big tech shadow banning, Their censorship, their double standards continues. We just heard a recent series of reports about NBC possibly goading Google to pull their AdSense away from the Federalist and Zero Hedge. It becomes more and more frustrating every day, it seems. But this does offer us some opportunities to learn and, again, to maybe pass it on to the next generation, tell them how crazy this time was, even as we watch the political heavy hitters go up against the corporate heavy hitters in a massive slug out where, unfortunately, we're getting punched around as well.